Hey, I'm going to talk to you about this guy, Mark Ludwig, who looks like the twin of comedian Ed Helms from the Hangover in Comedy Central. Why he's either straight up lying to you or he's totally ignorant and doesn't know what he's talking about when he talks about shared parenting. He's going around pushing, he's getting his rocks off, shaking hands with legislators, standing in front of the camera, talking about shared parenting. Everybody already knows dads are equal. So he's getting famous by saying dads are people too. And he's pushing for shared 50-50 parenting. And I have several videos explaining why that won't work. And because the average person doesn't have normal deductive reasoning of a monkey, this guy gets to mislead everybody that that's a good thing. So let me show you. And his Missouri 50-50 law, he brags about that all the time. And it's the worst one out of the 4 or 5 states that have 50-50 laws. It's the very worst one because it allows the judge to do whatever they want. It's specifically right. Well, let me tell you straight up. The law in Missouri says, let's take a look at it real quick. So look here, it says Missouri Revisor of Statutes, 452-375, okay? Now, let's take a look at what it says. It says there shall be a rebuttal presumption that award of equal or approximately equal parenting time. What does that even mean? So the judge has latitude to not make it equal or approximately. That could be 60-40 or 70-30 or 65-35. Whatever a judge thinks is approximately. This language is horrible, okay? Now let's go down and look later on. Let me see what section. I can't even see what section I'm in, but you guys are going to want to scroll down to, it looks like it's subsection 4. Let me double check. So yeah, it looks like it's section 4 of this law. It's in the best interest of the child to have frequent and continuing contact, except for cases where the judge says that such contact is not in the best interest of the child. What? There's a rebuttal presumption that continuing meaningful contact is in the... So that law says the best interest of the child is frequent and continuing contact, unless the judge says it's not in the best interest of the child. So they created this whole law and had this whole campaign to say, hey, 50-50 is what we presume is best for kids, unless the judge doesn't think it's best for kids. We're right back where we were with the generic best interest of the child and the judge doing and saying whatever they want. How can this guy be that stupid? How can he not read his own bill? And he's collecting donations from you guys to run around and saying pointless, moot laws. So that's the Missouri law. First of all, it says rebuttal presumption of equal shared parenting or approximately close to that. That leaves it wide open for them to say, okay, the other parent still gets custody and you still have to pay child support. Whether it's 50-50, a judge could say 50-50, but they could say 60-40, like I said, or 55-45. And then the other parent still got all the decision-making. There's no presumption of decision-making in here also. I think he's left that out of everywhere he goes and everywhere he talks. This guy is another dad in the father's rights movement groups who lost in court, running around, knows a little bit about the court, and doesn't know jack squat when it comes time to actually fixing stuff. On top of that, let's say he had a law that says that, let's say he left out that line that totally nullifies everything he says. Or maybe that was already in the law, but he didn't modify it. I don't know. This guy actually doesn't read his own stuff. This is insane. And he's running around and everybody like Ryan the T.U.F dad, who has hundreds of thousands of followers, promotes him all the time. And so does the father's rights movement. What do those guys do for dads? Nothing but post loser stories. This guy's affiliated with the Father's Rights Movement. Last time I was on a Father's Rights Movement page, one of their guys or somebody in the group told the dad, you better give your kid back to the mom, even though her boyfriend is a child molester and your kids get molested. Why did he say that? Because there was a law in that state in Idaho that said if you violate a court order, you can go to jail. And the guy pushed for the dad to not give the kid, to not withhold the kid from the mom. The child was being molested. And this dad said, you better give the kid back. First of all, if I get in trouble for protecting my child from molestation, I'm willing to do it. That's when you have these soft, gentle, nerdy, dorky, non-manly men out here at the forefront. And then I come out here talking about let's go to war and fight for our kids. No, I got full custody of my daughter without a lawyer when she was a baby. I've helped thousands of dads do the same. Get full custody, get 50-50 by fighting here and now. I'm not holding my breath waiting 40 years for laws to pass in all 50 states. I'm helping dads win right now. And this guy is puffing out his chest and bragging about how wonderful he is with these stupid laws that a third grader would read and say, oh, this is flawed. My sister with Down syndrome can read that and say, this doesn't make sense. This is what's best interest of the child, unless the judge says it's not in the best interest of the child. Leaves it, the discretion back to the judge. And the problem we have is abuse of discretion of the judges. How can these idiots not know that? Because they're not thinking, because they're emotional feminine males who think, oh, if there's a law that says presumption of 50-50, that makes the judges fix everything. Did you know that slaves were free in the 1800s? Do you think black people were treated like equal citizens the next day? They created laws to to go out and arrest black folks to put them back on the plantation right after that. And then it took another 80 years or so to get the civil rights movement and Brown versus Board of Education. This guy thinks that there's a law out there, everything's going to be honky-dory. The problem is the judge can do whatever they want. And let me go back to the Fathers' Rights Movement. So this guy on the Fathers' Rights Movement page, one of their little forums where everybody's giving all a bunch of loser dads are giving each other bad legal advice. I get on there and I say, what are you talking about? There's a law. He has to give the kid back. And then it took him about 20 minutes. He went and got this law. I looked at it. And see, the problem was the guy didn't even read the law. Just like Mark Ludwig doesn't read his own laws. This guy didn't read the law. He didn't read the law. Because later on, it said, like, the law was only like a couple paragraphs long. And I read all the way to the bottom, and the bottom said, it said you could get in trouble, you withhold a child from a parent, you can go to jail. And at the bottom, it says, unless you're doing it to protect the safety of the child. So this dad was doing it to protect the safety of the child. So the law didn't apply. But some numbnuts on the Fathers' Rights Movement Idaho page told him to give his kid back because of a law. The guy only read the headline. That's the type of mentality that these guys have. They don't spend time reading stuff, paying attention to stuff, or anything like that. They all lost in court and got creamed. And then me, a guy who won in court over and over and over again, and I show you my winning orders, they hate me because I call BS on their BS. Because I'm sick and tired of people running around lying to people. Now, let's look at laws, and I'll tell you the real solution with this stuff that nobody's even thinking of. When you go to family court, women lie about you being a child, dads being a child abuser, domestic violence like 90% of the time, or have an anger problem or an alcohol problem. They get custody automatically because of that. Now, nobody knows how to argue that because there's a presumption of innocent and there's no finding of you being an unfit parent. Troxel versus Granville kicks in. All the factors in each state kick in. Most states have, Illinois has 17 factors. Texas has a presumption of frequent and continuing contact. California Family Code 3020B says frequent and continuing contact is the policy and a presumption of joint custody and all this stuff. But there's always an exception. And Mark Ludwig, being the dummy that he is, writes in there, unless there's domestic violence or abuse. If women are already using that and lying about it, what do you think they're going to do when they say the dad gets 50-50 unless there's abuse or unless there's child abuse or domestic violence? They're going to do it even more. You can't be that stupid that you don't realize that. But Mark Ludwig and the Fathers' Rights Movement, emotional, feminine, you see, men have an ego, and then when they're acting like Simba running off and frolicking away from their calling and not being a real man and not trying to be king of the family and not trying to get custody, they turn into feminine, soft, gentle queens because they want everything to be nice and sweet. And they don't want to ask for full custody because that's blasphemy. They want to work with an alienating child abusing parent. They want 50-50. They want the child abusing mother, narcissistic mother, to have 50%. And they think they win Cub Scout brownie points, for asking for 50-50, while the other side is asking for no time for you because you're a monster. They win because you just said with your 50-50 attack or 50-50 argument that they're totally credible. Now, here's the thing that they should do. They should pass a law that says 50-50 and there's no exceptions unless there's a criminal conviction of domestic violence or child abuse or molestation or rape. Because those are crimes. In civil court, they base it on, does the judge believe her more than you? Boom, preponderance of evidence. They believe you. That's a crime, and you never get a chance for a jury, a judge, an attorney, due process. If a crime is going to be used against you, it shouldn't be used in civil court to skirt around that. But these numbnuts have never even thought about that. So There